It's a big thing for us to learn about the industry and for us to learn about the science, because it's this regulatory system that has to embody all of these concerns of yours and knowledge that you have. And this is a difficult thing for our legal system to sort out, because the federal government that Hannah just describes has limited delegated authority to deal with these things. They can't just regulate all aspects of fracking. The state governments, as Hannah's circumference showed, have, under the 10th Amendment, reserved all powers not delegated to the federal government, and that means power over property, power over land, power over industrial operations, which is what hydrofracking is. And then there's local governments. Local governments have been given authority to regulate a lot of impacts that you haven't talked about much today. I've heard several people talk about what are the risks of fracking. What are the risks? And I think the circumference is much larger than we've talked about, because there are a lot of local impacts that are not regulated at the state or federal level. So we wonder, why can't industry just decide these things? And I think, John, I'm indebted to you for your remarks. We've got to get this right. We have to get these industry best practices into the regulatory system. And how do scientific standards fit into this regulatory system? That's what we're about on our end of this debate and discussion. So the feds have left many impacts unregulated. The states historically have regulated gas and oil mining, and the states have left many local impacts unregulated. Let's take a look at some of these local impacts. And some, as Hannah just described, some of the states are regulating some of these things. But from a local perspective, what we're first concerned about is our land use pattern. We're concerned about our community. We're concerned about our comprehensive plan. We're concerned about our neighborhoods. We're concerned about a whole number of things that have been outside the discussion so far today. We're concerned about traffic safety and road conditions and repair and dust from the trucks. And we're concerned about noise and night sky illumination, viewshed interruption, local economic development plans that we have that may include things other than the gas and oil industry. Wetlands and habitat protection are concerns of ours at the local level, along with soil erosion and sedimentation, ridgeline protection, and protecting critical environmental areas that we've taken a long time, the last 20 years, to identify. And there are many, many more. So it could be that land use law, which I teach, and I run a center called the Land Use Law Center at Pace Law School, and we now have 4 land use courses in the FES curriculum, and we're about to bring on a clinic in land use. Land use may be a special case because the federal government has made it very clear in a number of statutes that we don't touch land use. That's a state concern, state legal authority. States defer at the legislative level to local governments because all politics is local, and most state legislators are from local areas. So they defer to local authority and local concerns. And then we have this comprehensive scheme in states that go completely to another point on the regulatory map, where we have given local governments the authority to adopt comprehensive plans, to adopt zoning, and we have told them that it's the land that they've regulated that they can tax, which revenues they then take to pay for municipal services. And this is a state regulatory construct, this planning and zoning and municipal finance and municipal operations. And you see, what the state governments have done is create all this law that says that's our system for deciding what goes where on the landscape. So you can't push this level of regulation out when you begin to talk about hydrofracking. So I'm going to go real quickly through the Marcellus states and talk a little bit about what's going on. There's this tremendous confusion in New York where the oil, gas, and solutions mining law says that it supersedes all local laws or ordinance relating to the regulation of the gas mining industry, but shall not supersede local jurisdiction over roads and real property taxes. That sounds pretty clear on its face. We just pushed the local governments out the door. But did we? Did we? And it turns out it's a very long story in New York. The courts don't agree so far with that statement on its face, what it seems to say, that the local governments are preempted. There's, in fact, because of this three-legged stool that I just talked about, there's a presumption against preemption of local law. Zoning empowers local residents. It furthers democratic values. It's part of a whole comprehensive legislative scheme. Judicial preemption at this, of local law control denies those values. Our law says that local power shall be liberally construed. So does this then mandate a very narrow reading of this supersession language? And the courts have said that it does. The town of Dryden and the town of Middlefield, and I want to point out what's happening here because on one level it's not a good thing. These two towns talked to their lawyers, and their lawyers said, you have the authority to regulate hydrofracking. And so they both did it by preventing it in the entire jurisdiction. Now, John, to your point, if at the local level we regulate out gas drilling, we're going to have the states slapping our hands and doing something to control that. But these two towns did that in different ways, and they were both sued, Dryden by a drilling company and Middletown by a local dairy operation that had leased its land to a drilling company. And both courts at the lower court level held that zoning can regulate the location of gas drilling while the Department of Environmental Conservation has the exclusive authority to regulate drilling operations. Not a clear distinction, but so much of what we've heard today from the industry and from the environmental community is that there are things associated with the actual drilling and the operations of the gas itself, of the pad, and all of the extra facilities, that is regulated by the state. So you get a single permit that tells you what you have to do with respect to your operations, but that the location and all these local land use impacts are still within the regulatory authority of the local governments. So they said there's no express preemption in New York State. The statute creates separate regimes for regulation, and the oil gas solutions mining law deals with operations of these facilities, and zoning deals with their location and local impacts, and they can be interpreted to coexist, and so we're not preempting local regulation. Think of that, 1,600 local governments in New York State as of today have the authority to regulate this industry. Now, in Pennsylvania, the state legislature stood up tall and said, we don't want any of that. We don't want any local interference in regulating the hydrofracking business. So they took it away with what that was called Act 13. And it not only preempts all local zoning regulation of hydrofracking, it requires all local governments to put oil and gas operations in as of right uses in every zoning district in the state. And I think there's 2,600 local governments in Pennsylvania. So the effect is, according to the court that looked at this Act 13, the effect of this Act 13 is to violate provisions of local comprehensive plan and local laws as to uses, heights, screening, fencing, noise, lighting, all those other impacts that I just mentioned. The state legislature has said, no, you're going to put fracking in as an as of right in every single zoning district. And in a case, 2012 case called Robinson versus Commonwealth, which was very narrowly decided, the court in Pennsylvania held that the preemptive effect of Act 13 is invalid. And what it says is it makes irrational distinctions so that if the local government had decided that hydrofracking facilities could go anywhere in any zoning district, that would be called an arbitrary and capricious decision, irrational, and it would be set aside by the courts. The court looked at this Act 13 and said, same thing with the state legislature. That's just too arbitrary to require even residential zones to have hydrofracking facilities. So the current situation in Pennsylvania is a little bit like we have in New York. There were two cases decided before Act 13 and before the Robinson case, and one held that the local government could control the location of wells consistent with established zoning. That was a Huntley and Huntley case. And the other case held that local land use cannot regulate operations like wellhead construction, as Salem Township tried to do. Now, in West Virginia, Morgantown is a city. It's been going crazy trying to regulate fracking. They first regulated fracking out of the area 1 mile beyond its borders. That was set aside by a court. They then came back and they set aside certain areas within which fracking couldn't happen. They required setbacks from churches, hospitals, daycare, residential areas, etc. And that is probably now going to be litigated. So the question becomes, given the three-legged stool that I talked about and the tremendous power that's been delegated to local governments with respect to planning and zoning, when Morgantown comes back with a more reasoned and less extreme regulation, is it going to be upheld, or are they going to say the same thing that they said in the first Morgantown case, that this authority has been taken away? I think that the local law that I've talked about in West Virginia has a lot of strength and could lead to the same results as we've seen in Pennsylvania and New York. And then in Ohio, we have this Newberry Township case, which said that local governments can regulate fracking if they can discreetly show that it's for local public health and safety reasons that they're doing. They regulated out fracking from all residential districts, and it turned out that all the residential districts had a lot of agricultural land in them. They had no agricultural zoning, and the courts decided that there's no basis for preventing fracking in those residential areas because there's been no showing that it protects local public safety and health. So we're very much in the same position in Ohio as we are in New York and Pennsylvania, and I think we may be in West Virginia. So the presenting questions, this is my last slide. The presenting questions are, how can the federal, state, and local regulatory regimes be coordinated? You see what we've got is a very fractured, to use the term, regulatory system. And then as we go about this, how can the federal, state, and local regulatory regimes be informed by the science that you know? I was struck so many times this afternoon as I was listening to you about how would I possibly communicate what you were communicating to us to local officials who are trying to regulate some of these impacts. We need to be able to do that. Is it possible for a state regime, and Hannah, this would be an interesting question for us to collaborate on, to protect the interests that are normally protected by zoning? Because if it's not possible for the state government to do that, then there's got to be some room left for local governments to regulate. But then how do we measure this? As John said, this is a tremendous economic opportunity for our country and for our local communities to take advantage of this incredible resource that we've found. And we've got to be sure that we do this correctly. So how can we give local governments a meaningful role in state decision-making? How can we maybe expand state decision-making so that it includes some of these local impacts? How do we put in the right place the regulations, the science, the best practices from the industry into this rather difficult to understand regulatory system? Thank you.
Thank you.